Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Steve Pateco, and I'm presenting today with Ross Gorn from our Philadelphia office. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website at www.wglaw.com. And you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is Stop the Bleeding, Ways to Manage Medical Claims in Pennsylvania under our workers' compensation system. So let's get started. All right. Medical benefits, they're a big part of the workers' compensation system. In past days, we used to think the indemnity claims were the driving cost of the system, but in many of our claims now, the medical benefits exceed the indemnity claims by a great amount. Managing those medical claims is very important to keep your cost under control and to handle workers' compensation claims properly. So just a word or two, medical benefits are required to be paid for work injuries in Pennsylvania under Section 306 F.1. That's the governing statutory language. This requires payment of reasonable surgical and medical benefits for treatment that is causally related to the work injury, reasonable and necessary, and properly presented. When there is no loss of earnings, you may still be required to pay medical benefits. They must be paid within 30 days, and reimbursement is fee capped at 113% of Medicare. Medical benefits payments are not an admission of liability. This is a very important factor to keep in mind as you're managing medical claims. Now, Ross, do you have anything to add to our basic comment on medical benefits before we dive into the tools to manage?
No, I think you're exactly right. Medical is a big complicating factor in a lot of these claims now, and there's certain tools that a lot of people are just learning how to manage that cost, that driving factor in these. So,
okay, what you came here for, tools to manage these medical exposures. We're going to today talk about basic tools, things that everyone should have in their toolbox, and some advanced tools, things you may not even have heard about or utilized to this point. But it all starts with the basics, and we're going to start first off of this list with use of panel providers. Establishing a panel of physicians can be your primary tool to manage medical claims. What are the advantages? If you properly establish and enforce a list of panel providers, you have 90 days of captive medical treatment, or I'll call it good medical treatment. The injured worker must treat within that panel. And if he does not treat or she does not treat within that panel, you don't have to pay the medical expenses. The employer is not responsible for those payments. Now, that's a big assist to employers, because you're keeping your employees with good physicians you know and trust and have good communications with. This can make a big outcome in the treatment experience of the injured worker. You're keeping them away, at least during the first 90 days, from doctors that say provide questionable treatment, can claim it down a path you really don't think is right for the claim, or refer them out to attorneys that initiate litigation before it's necessary. So with that in mind, we have to first establish the panel and how you do that. What are the requirements of doing that? We don't need to get into all the nuts and bolts. It's all spelled out in the statutory language, 306 F.1. But you should know the panel can be pretty extensive. You can list various different specialties depending upon the nature of your workforce and what kind of injuries you might encounter. There should be at least 2 physicians on the panel. You can designate coordinated care organizations to be part of the panel. and the specializations can cover the gamut. We most often see orthopedics, orthopedic surgeons, neurologists, ophthalmologists, but it all depends on your workforce. You can see chiropractors, and bear in mind, if you have all these areas covered with your own specialists, then you'll find the employees don't have to seek those specialists outside the panel. So ways to enforce the panel. You can spend a lot of time establishing a good panel, but unless you do what's necessary, you can't keep the employee within that panel. And here's what I mean. The Act is very specific. It requires that you have the employee sign an acknowledgement of rights and duties. The statute spells out what information must be in that, but it's all reduced to form now. So we have forms from the Bureau. We have forms created for different clients. The important thing is to present this to the employee and have them acknowledge their rights and duties, including the duty to stay within the panel for the first 90 days. That is to be evidenced by the employee's signature and date on the form. Now, and what if an employee refuses to sign a form, Ross?
So the Act does speak to that, and you're not out of luck. And what that says is an employee cannot refuse. So keep documentation of that for if that becomes an issue, so that you can present to the courts and you can maintain your right to keep it on treatment on the panel in 90 days.
All right, now, when do you get the acknowledgement? Well, time of injury is a logical time, and it's right in the Act that that's when you must have the employee sign the notice of rights and duties. Easily enough, the employee notifies the employer of an injury, part of the discussion of what happened. Here's your rights under the Act, get them to sign the form at that time. That's not the only time you have to have this type of form signed. The Act, again, is very specific on this. You have to have a notice of rights and duties signed not only at the time of injury, but also at the time of hire. So when the employee comes in, begins work for you, you have to have them sign the form. That can be done if it's made part of the typical orientation paperwork. There are ways to accomplish this, but if you don't get it signed at those 2 points in time, both the regulations and case law say you can't enforce the panel. So it's kind of useless to spend the time and expense of establishing a good panel of physicians if you don't follow up and get the necessary forms signed when you need to have them signed.
I think one thing to remember with utilizing your panels is this is, when thinking of medical throughout the duration of a claim, this is your first shot at controlling medical costs and keeping, the idea is to keep the injured employee on the panel and wanting to stay on the panel. The sooner they get off the panel or are referred by an attorney, that's when things get complicated. You can't track the treatment as well. This is also a time for you and the employers to establish a plan of action when you're designing your panels. You want individuals or doctors on there that know the job, and don't be afraid to have the doctors on the panel come on site and see the job. There's nothing stronger down the line than having a doctor testify, go, well, I've seen the job, I know the job personally, and give an evaluation as to what the injury is, what the duration and the nature of it. That is a big benefit.
That's a great point, Ross. Think of this in evidentiary terms. If your case bubbles up to litigation, if you have a physician on the panel who's willing to testify that can say, I've been to the job site, I've seen the job in progress, I see routinely workers that come into the office that have performed that job, you're in a much better position to convince a judge your expert is credible than a physician has never seen the workplace or seen the job in progress. So if you have that kind of relationship where you can establish a panel that has access to the workplace, a relationship where they know they're going to get a lot of work from that area, they are well-versed to go out there and learn what the jobs are that they might typically see. So that's a great point.
Now, one question is to contemplate is, what about when there's an emergency situation and you need to get these forms signed to keep them on the panel.
Well, that was a hypo I was about to present to you, Ross. I'm going to just kind of play out a scenario that some of our clients would perhaps see and see what the legal eagles have to say about it. So you have a individual who's hurt on the job. It's a bad injury, an emergency situation. They're taken directly to the hospital by ambulance. Haven't had time to sign any forms. Is the employer out of luck when it comes to having that employee treat within the panel?
No, and actually there is, the regulations speak to this, which is that you can get the signature as soon as practical after that emergency is gone. So
okay, so they're discharged from the emergency room. They're not coming back to the workplace because they're injured. Adjuster, investigator, somebody goes out to the house, presents paperwork after checking how the person is doing, everything being taken care of. And that's when you notify them of their rights and duties and get the form signed. If you don't get it signed, you're going to have a problem utilizing the panel. Let's bend that hypo a little bit, Ross, to consider this. After the emergency, the employee at home has signed a notice of rights and duties, but they were hired 15 years ago before anybody ever thought to use panel physician. Never signed any notification of rights and duties then. Is the employer out of luck?
Yeah, you need the 2 points in time. The biggest thing and the reason they have this is to give adequate notice of what the employee is required to do and at time of hire and before the injury is needed.
Now you might think notice at the time of the injury is sufficient, but in black letter law, in the regs and in case law, it says you have to have it at 2 points in time or you can't enforce the panel. It's unfortunate. I mean, the panel you present at the time of hire might be very different than one 15 years later when the employee's injured, but this is unavoidable. And I've heard judges say this from the bench and in seminars. First thing I look for is a panel acknowledgement, 2 points in time. Without it, you're out of luck. All right, so let's move on to second major step in your toolbox here. Determining the causal relationship. When medical comes to you in the form of bills and reports, the first thing you do is determine whether it's causally related to the work injury. And the first step in that regard is determine what the injury is. Now well, first place we would normally look to is the bureau documents, where the injury has been accepted. NCP, temporary NCP, medical only NCP. This is what defines your work injury. Now we know those documents are kind of forced to be filed in a very short period of time after the injury. If the 21-day rule requires you to make a determination, compensable or not, and what is the injury. You don't have much information in 21 days. Sometimes you do, sometimes you don't, but you have to file something. And with our new EDI process, you make an EDI upload and the Bureau actually issues the form. And sometimes it doesn't have a great deal of specificity or relationship to the data that's really input. So we see in our practice routinely petitions for review of the injury description because it's so badly described in the Bureau issued notices of compensation payable. So that's one place to look. It's not the only place to look to define the work injury, but there are limitations. And we'll get into what you do about those limitations in a minute. Second place I would look if I was trying to determine what the injury is whether any supplemental agreement was ever filed. In that, you can describe the injury. Third place is whether there has been a judge decision in the past. Often, and these days quite often, we have review petitions to deal with, and we'll try to resolve them early on in the case by stipulation. We want to know what injury we're working with right from the beginning, because when it comes to having your IME or your expert review, you need to tell the doctor what is the compensable injury, and then take care of the other issues from there. So you should, and I think Ross will agree, be flexible. Everybody knows you're not going to have enough information to fully define the injury in the first 21 days. So be flexible. If it comes time to amend the injury description, do so. It will save you some litigation downstream. It'll give you a more accurate history of the claim, and it'll give you a yardstick from which to measure the medical expenses coming in to see whether they fit within the compensable injury or not. Any thoughts on that, Ross?
So it's also, and I agree with that 100%. It's also good to be flexible and sensible with the types of treatment that you're seeing in those initial stages. You want to keep a good relationship with the claimant and the employer to kind of keep this out of litigation. Also, and remember, keep in mind here, just because you pay something does not mean you're admitting liability, and that's a big thing. And within that 21 days, the first 21 days when you need to file something, there are nowadays the temporary comps, which give you a 90 days to further investigate, which you can then look at records and determine what other treatments are out there, any pre-existing conditions. Utilize IMEs during that period to help manage the exposure and to see what's going on to help you accurately define the injury. Those are big things to look at.
So if you have a defined injury, you know what you're working with, medical bills come in, and there's treatment that's obviously not related. What do you do?
When it's not related, again, go to your bureau documents, but you can deny the treatment. You issue your EOBs. Be specific on those explanations of bills,
of benefits.
Of the benefits on the bills. Be specific so the judges know what you're working with if it goes into litigation. And you can deny the bills if it's not related. Now, also, when you're seeing treatment for other body parts that are out there that you haven't accepted combined with body parts that are accepted, ask for the bills to be unbundled, separate out the charges, and pay what only you are responsible for.
So in a real life example, you receive a bill. Well, you're defining your work injury initially as cervical strain sprain. Bill hits your desk. As treatment starts growing, it starts out as cervical strain. Now you're seeing, typically in chiropractor bills, thoracic, lumbar treatment. You're comparing this to the accepted work injury. You're seeing body parts that aren't involved in a work injury. This is a perfect time to question the doctor. Issue the explanation of review, noting non-causally related treatment, deny the bill, ask the doctor to unbundle the charges. Tell us what you're charging to treat the neck, what you're charging to treat thoracic, what you're charging to treat lumbar. Pay the neck, but not the rest. So unbundling is very important and should be utilized whenever you have a clearly unrelated condition. What about situations where there's a question, you're not sure it's related, you need some more investigation, you might think there's a pre-existing condition that is now being pulled into the comp claim. What do you do then?
Well, there's several things you can do. You can deny the bill. You can do that, but you also have some tools. You can also amend the description of injury. But if you question whether or not it's related, you also have IMEs at your disposal. Get an examination, get an independent medical expert to tell you what the injury is and what the extent. Also, if you send out authorizations and you get them back signed by the claimant, send that out to his providers, his family doctor, to any ERs that he may have treated with that can give you some information to give you a better picture of what's going on here. Those are key. And again, if you have a temporary compensation payable, temporary notice, you have 90 days where you can adjust and even pull back that temporary comp payable. So utilize the tools that you have available there.
So your duty to investigate the claim continues. It's not over when you issue the NCP. And it's an ongoing process. All these are great suggestions, Ross. Continue to investigate. Go to the source of the records that can help you determine if there's something else in play other than the work injury and treatment for it. Now, let's move on with a little, no, don't change the slide. Let's move on to another situation where this causal relationship can arise. Your claimant is treating for, say, a lumbar strain and sprain, and that's defined as the compensable injury. Now you have a surgeon calling up, says he wants to do lumbar disc surgery. What do you do under that circumstance?
There's there's a risk of a penalty here in this instance if you deny it outright. And what you have to be wary of is of giving a specific approval or denial. What you can do in these scenarios is let the doctor know we have an accepted claim for, let's say, a lumbar strain and sprain. We are paying medical benefits that are reasonable, necessary, and causally related to that lumbar strain and sprain. You can submit your bills for the surgery. They will be reviewed and paid so long as they're reasonable, necessary, and causally related. And that's an answer where you are saying, yes, we have an open injury, we're paying benefits. And that's all you need to say.
Right. You're not acknowledging that you're going to pay for that particular procedure. You're acknowledging there's an open claim. You'll pay what's reasonable, necessary, and related, but you're not committing anything. Now, my suggestion is if you're in a conversation with the doctor or doctor's office like that, make a contemporaneous note, because you'll be surprised later on in litigation when this issue comes up. What you say you said is not what they say they heard. All right. We'll get vastly different recollections of that conversation. But if you have a contemporaneous note made, it will help you defend your position. What Ross mentioned about a possible penalty, that's under the McLaughlin case. It basically says if you challenge or deny surgery for a body part that's compensable. Remember, we said the lumbar is accepted area of the body. You think it's a strain sprain. Doctor thinks it's a disc. If the judge determines the doctor's right, you could be penalized for not paying for that surgery. If the judge determines you're right, doctor's wrong, you win. But there is a risk of the added cost of a penalty if there's surgery applied to the same body part that's compensable that you've denied. Different scenario would apply if there's surgery for a different body part. Say you have accepted a back injury, doctor wants to do knee surgery. Now it's going to be a different analysis because that's beyond the scope of the body part accepted. So it's just something to be aware of. Basically, the ante is upped when you're denying surgery for an accepted body part. It might cost you more to defend, so you want to be very sure. Make sure you do your investigation. Hopefully you will have some medical evidence to present to support your positions. You have an IME, you have a record review, you have somebody who's commenting upon whether this surgery is for the accepted injury. And be sure you have the accepted injury described correctly. If it is a disc injury and you know it, you should really amend your documents, your bureau documents, to bring it up to date so you have a good description in the administrative system. It doesn't pay to minimize the description, try to maintain a minimal description in the face of obvious medical evidence to the contrary. But it has to be reliable medical evidence. You have to have, physicians that you've checked with, that you rely upon, that you think have had the most and best information to review. But once you're sure, don't be afraid to amend the descriptions. It's better in the long run. And that's what we mean by be sensible and flexible.
Yeah.
All right, we'll move on to the next major tool in your toolbox. After you've determined the treatment is causally related, your next step in the analysis is determining whether it's reasonable or necessary. I'm going to let Ross carry the ball here.
And this is when utilization reviews come in handy here, because again, as Steve said, you've looked, determined it's causally related, but now bills are piling up. The treatment seems to be endless. What do you do here? You file a utilization review, which looks at whether or not the treatment from a provider is reasonable and necessary. To do this, you need to file or request the utilization review, and you need to specifically identify the provider at issue here. These are provider-based, not treatment-based, which comes in play down the road here. So be specific about the provider that you're putting under review. If it's a physical therapy company that has multiple physical therapists, but one doctor overseeing everyone, what you should do in those scenarios is identify the doctor prescribing the physical therapy, as well as the company or the organization that's doing the therapy. From a timing purpose, this is also important. You have 30 days from receipt of the bill to file or request the utilization review. In the context of a claim petition, or down the line, you have 30 days from the decision or from when you accept the injury here. But it is important, again, to name those providers and have that timely done. Once that happens, the utilization, you have an automatic supersedious where you don't have to pay the bills until you get a determination from the utilization reviewer. If the reviewer determines that the care is not reasonable and not necessary, you don't have to pay. If they determine it's reasonable and necessary, then you have to pay immediately. These determinations can be appealed as well by the healthcare provider or by the claimant. If they appeal, it needs to be appealed within 30 days. And again, if it's not reasonable and necessary, then you still do not have to pay while it's being litigated, which will go before the workers' comp judge. Now, if you get a determination that's not reasonable and necessary, again, you have the same option to appeal that determination within 30 days. And you can present evidence. One of the biggest things to do when determining whether or not you want to appeal a UR determination, look at the treatment records of the provider under review. If it shows no progression in the symptoms or that the claimant's not getting better, don't be scared to file that appeal. What'll happen at that point, again, it will go to a workers' compensation judge, and the determination will be put into evidence. So if it's one that did not come was not in your favor, you can also get a records review, you can get an IME, you can submit the actual provider's reports that do not show any progression in the treatment. So I think that's big in those scenarios, and I'm sure, Steve, you would agree with that.
Yeah, just to review a little bit, this whole system is designed to give the employer the opportunity to challenge before they have to pay a bill. But they don't want to keep the providers waiting forever. So there's that timing requirement, 30 days. 30 days from receipt of the bill, 30 days from the decision that creates the obligation to pay. So the idea is a quick review, but in the meantime, you're not going to have to pay the bill. Supersedious runs until you get a determination. So the whole system is designed to be quick. Now, what you're getting is a review by a utilization reviewer who has a cold record. He's not going to see the individual. He's only going to get records from the provider. The provider's records, that's what he reviews. And he has to determine from that whether treatment seems reasonable or necessary. When it comes to litigation, after the utilization review is done, parties appeal, it gets before a workers' compensation judge. The judge sees the UR report. And he's going to see reports from the treating physician. And these two, they don't match up very well, right? The utilization reviewer, again, is limited by not ever seeing the patient, not hearing history personally. He applies some of his background training in rendering an opinion, but the treating provider is always going to have the advantage of having personally seen the patient. So if you want a better experience, you have to juice up your evidence a little bit, and that can be done with a coordinated IME. You have a medical opinion from an expert who can write a report or testify in a serious enough situation at about the same time the utilization reviewer is conducting his review. That's important. You hopefully have an IME by a specialist who has, especially for the treatment that needs to be considered. Records reviews can be done short of an IME. And Ross had a great suggestion with submit the reports from the providers that often will show just repetitive, same thing, every report, barely change. It just looks like a word processing report, and no change in the treatment pattern, results, just no change, just continued treatment with bills. Judges will pay attention to this.
And frankly, there's nothing greater than seeing the doctor who they'll have their treating doctor submit a narrative statement saying why their treatment is reasonable, necessary, and is doing great benefit. But there's nothing better than sitting there and submitting the reports from that same doctor that show the claimant's not getting better, still has pain, 8 out of 10. Next week, 8 out of 10 pain, not got better, didn't get better from the treatment, and goes on for months. The judges look at this. They have this view where they go, well, this doctor's saying one thing, but his treatment notes show something else. That is a great piece of evidence to contemplate in litigating these types of petitions.
So I guess the bottom line is, if you're going to be in litigation on a petition for review of utilization review determination, don't just rely upon that UR determination. Try to get additional evidence, because that'll give you a better litigation outcome if you have better evidence.
Now, one thing to keep in mind with respect to these, and we talked about supersedious, is if you have a determination, it says it's reasonable and necessary. You appeal that to the judge, and the judge ultimately determines that the care is not reasonable, not necessary. You do have the right to get reimbursement from the supersedious fund. So that is something to keep in mind in the future with regards to that. But again, utilization reviews are a great tool. One thing to also keep in mind is it does presume that the care is causally related. So that's something else to keep in mind.
And if it's not, take a step back to what we said in the previous slide, which is challenge for lack of causal relationship. But once you file the utilization review, the presumption is the treatment is related to the injury. You're really not challenging that. You're only dealing with the secondary issue of reasonableness and necessity. So I think that's the two of your major tools in the toolbox. Then what do you do if you've paid the bill, the doctor doesn't like the payment? He says, or she says, it's not the right amount. It's not timely. You've waited 8, 12 months to pay the bill. Well, the doctor now has remedies. This system, as I said, was designed to compensate quickly, get a review quickly. If the doctor feels it wasn't done correctly, he can file a request, or it can be filed on his behalf for fee review. Now, this has an administrative aspect and then a legal aspect. The administrative phase allows review by the Bureau. After the doctor files a fee review, there's usually contact by the Bureau with the third-party administrator, insurance carrier, whoever's administering the claim. There's been a challenge to these bills for these reasons. What say you? And they want to hear your side of it. And if you say, well, it's not causally related, kicked out of the system. It's not the issue. If you have a reason to respond to this issue of timeliness or amount, you present your case. And then it's not, a legal proceeding. You just communicate with the reviewer. They will then spin out an administrative determination. And this usually says what the bills were, the dates of the bills, the service, the coding, the amount paid, the amount determined that was due but not paid. And it will say you should pay X amount extra with interest. Sometimes it says you've done everything right. You don't have to pay anything more. Well, when that happens, we always see the next step, which is a demand for a hearing de novo by a hearing officer. So that's the litigation phase. This now moves from the Bureau to a hearing officer who will schedule a hearing, usually conducted by telephone conference, where the issues are reviewed again. Determination is going to be made ultimately as to whether the correct amounts were paid. The burden of proof is on the employer in all phases here. So you can stand on your administrative determination and say, well, we like that, but if that's all you do, you lose, because you have to now present evidence to this hearing officer to sustain your burden of proof. And you have to prove the amount of the payment was correct because you've determined through the codes that it was correctly applied. You have to determine whether, well, one of the issues that we often examine, first of all, is whether the request for fee review was timely, 30 days from the doctor's receipt of the explanation of review, or 90 days from the submission of the original bill. Doctors can't wait forever to do this. They have to do this quickly. And then there's typically 30 days from the administrative determination to request a hearing. We look at that issue first. If they get beyond that issue, we look to the coding disputes. Other issues that can arise in that litigation are whether the treatment was trauma versus non-trauma. Trauma treatment is compensated 100%. Burn center treatment, level 1 and 2 trauma cases, there's no fee schedule reductions for those types of treatment. So we sometimes get a dispute like that because the fee schedule reduced the bill significantly and the provider says they disagree. Many of these issues will be resolved by stipulation ultimately after the parties have a chance to discuss the issues, review what's been submitted. We find the other attorneys who handle these cases are very willing to enter into stipulations, providing for payment, often excluding the interest that's obligated to be paid under the Act, just to get the matter behind them. And I'm going to let Ross talk a bit about self-referrals. This is something that arises in the fee review process, or can arise in the fee review process. He has some very discrete experience in this regard, and I think he's happy to share that with you.
So the self-referrals, this instance comes, and we see this a lot with pharmacies, is you have a doctor, he's treating a patient, and he's prescribing medications or sending them to a treatment center that's not his on his own, but a separate treatment center where he has an ownership interest in that. And that's a big concern.
What's wrong with that? It sounds like a great way to make money.
It does, but you're driving up costs and it's wrong. There's actually a section of the Act that talks about that. You cannot do that. And
you cannot refer a patient to a service that provides you
compensation, where you get a profit from it. If you have an ownership interest, if you're getting profit from it, you cannot do that. Now, that becomes a big issue here. Now, there are ways you can deal with this. And what it says under the Act is if you have a basis for denying on a self-referral, you have to issue the explanation of the bill, and on that EOB, you have to explicitly state that you're denying it on the basis of a self-referral. What will happen then?
As opposed to, it's not causally related, it's untimely, something else.
That's correct, because the Act does specifically state that as a requirement, you need to state your basis for a self-referral. And that's because there are different triggers that arise in a different process that this takes with respect to a fee review. What will happen is if the doctor or the physician files for a fee review saying, well, I want this paid, it automatically goes to a hearing officer for a de novo hearing. And again, it is the burden of the employer, whoever is paying the bill, to prove the self-referral. So you need to have evidence if you are going to do this. Now we have, and as Steve said, I've had some discrete experience over this. We've dealt with this issue in the past, and we've obtained articles of incorporation, percentages of certain physicians that have ownership in pharmacies that have become a tool and allow us to look at this in the future. Another benefit is that in these de novo hearings, Steve, you can take testimony from witnesses and you can file subpoenas. You can get that information, because one of the things that you need to do in proving your case here is to show that the self-referral does not fall within the safe harbor exceptions. So it is a
Medicare safe harbor.
And the Medicare safe harbors, yes. So it's a very detail-oriented process, but it can be a huge tool controlling medical expenses for compound creams, which we've seen pop up. Pharmacy bills or pharmaceutical bills that are thousands of dollars, opioids that you get hit and you're paying for years and years. These are a different, it's a different point of view to how to really reduce that exposure and deal with those issues. So that's something that you can have in your toolbox for down the road. Now, again, it is really important that you have evidence of the self-referral, and as we've stated, is we are starting to see a lot of this pop up, and we have been able to obtain some evidence through this process, and it is a unique way to deal with this.
So just to flesh out an example here, you have a pain management physician who's sending the claimant to a particular pharmacy where opioids are being prescribed week by week by week in an endless cycle. And you suspect that doctor's doing that for a financial reason. What's your next step?
Your next step is if you suspect, what you can do is talk to the other adjusters. Are there any information that they have that this doctor has an ownership in that pharmacy? And if that doctor does, what you can do is issue an EOB and on that say, we are denying this bill on the basis of a self-referral. Deny it. And that'll go to a hearing officer and you can present that evidence to the hearing officer.
You can present the evidence, but so far I've only posited you have a suspicion. You don't really know. Once you get before the hearing officer, can you subpoena records?
Well, you can subpoena records,
okay.
and that's something else. But the point is, if you suspect, yes, you can file or deny it, and on those basis, and then subpoena. It's better if you have the evidence.
Of course, we'd love to have it, but I understand that you've actually been able to do this, subpoena articles of incorporation for certain businesses to determine who owns the business.
So I've actually done that, and what happens is you can subpoena it. The hearing officer has the power to issue that subpoena. Now, it's about 90%, if not more, the pharmacies will not supply that information, and there are avenues to further pursue the records that you're seeking in your subpoena. We have taken this to the Court of Common Pleas. There's also some pending in higher courts and in the Commonwealth Court, but we have been able to prevail in instances to get that information, and it's become very useful in these analysis and in these types of hearings. So,
all right. So what I take from this is, if you suspect there's a prohibited self-referral going on, you don't want to initiate litigation without pretty good probable cause.
Yes.
And you have to be willing to see it through, which means enforcement of subpoenas, getting the information that way. But I think you suggested to determine whether you have probable cause, ask around. The information's out there now. We've seen newspaper articles about who owns what in this regard. We've gathered evidence through depositions, who's involved and what interests particular experts have in other businesses. There's more and more of kind of a bank of information developing. That's probably the first step to determine if you have probable cause to suspect there's a real self-referral going on. Be sure, then take the step and then be willing to follow through with the step, because it can have a number of good effects, not just the litigation effect of one case winning and avoiding the medical bills, but when some of these practitioners find out they're under scrutiny, they may back off a bit. I know when we've had some physicians that have been forced to testify about these issues, they've pled the fifth. They don't want to admit certain things on the record. Now we'll have to sometimes do an end run to get the evidence through other means. But you can imagine physicians being uncomfortable having to be put in a position of answering these questions when they know it's wrong. So you might have an effect beyond just a single case when you do it right.
Yeah, these are things that providers don't like out there. I mean, it's something that does not look good for them. And again, talk to the people you work with. And again, when this information gets out there, Steve, the judges know, and it can create a greater scrutiny that's put over them when they appear before these judges. So it's a tool that not only has an immediate effect, but could have an effect down the line. And again, this is one where you really want to pick your battles and look at the big bills. If you're getting 5 figures worth of medical bills from compound creams and pharmacies and medications, then this is a route that you may want to pursue. So,
well, it dovetails nicely with our next topic, which brings us into the advanced tools. And I know we spent a lot of time on the basics, but it's important. The advanced tools we'll utilize less often, but in the more serious cases. Scrutiny, which is what we were just talking about, applies to this as well. One suggestion to increase scrutiny on physicians where you suspect something's going wrong is to have a peer-to-peer treatment review. This is doctor reviewing another doctor's treatment, formulating a report, making suggestions, alternatives, different approaches, less expensive treatment modalities. These things can be addressed completely by a third party, objective third party, and then presented to the treating physician. This can be done by a medical management nurse, can be a physician-to-physician phone call. But I've seen this utilized, and in the correct cases, it can have an effect on the treating physician. Sometimes they're cooperative, and they see some good recommendations and adopt them and incorporate them in the treatment. And at a minimum, they know they're being watched. They know somebody's willing to criticize their treatment and call their attention to the correct standards of care. This in itself can have an ameliorative effect on a claim going forward. A subcategory of this, and I saw one recently that I was very impressed with, is a pharmacotherapy analysis. I'm sure we all have cases. Some of these I call the immortals that seem to never go away. They just sit on the shelf and bleed and bleed and bleed. Opioids prescribed after 5, 6, 7, 8 years. It's just unbelievable what happens in some of these cases. A pharmacotherapy analysis I saw reviewed such a case. There was extensive treatment, and the reviewer applied the latest research, CDC guidelines, standards of care in the field to, in a nice way, criticize what was being provided by the prescribing physician. He described what the medications were for, what the usual application is, what off-label applications may apply, various alternatives to what was being utilized, often much cheaper, generic alternatives that have the same effect. What's the purpose of prescribing a name brand when a generic will do? So on, right down the line, with substantial cost savings. And the program was to have this physician contact the treating physician, review this report with them, and believe me, it was supported with medical research, citations to articles. Hard to dispute the recommendations made. I'm sure there's still some discretion in a treating physician to do what he thinks is appropriate, but it could be a very persuasive piece in the right kind of case. So that's one form of attack. I'm going to let Ross carry the ball on the next couple of suggestions we have.
The other way, and the big 180 on this one, is to look at the treatment that has been offered, and if the claimant is refusing them, you can file what was known as a forfeiture, but a petition for refusal of reasonable medical treatment. Now, in correlation to that is, let's take Steve's example with the individual had a lot of medications, a lot of opioids. What can you do in those scenarios where you know that they're having an effect on the employee? It's stifling the possibility of getting them back to work. What can you do? Wean the person off the opioids. How do you do that? get an analysis from a doctor to discuss a treatment plan, a recommended treatment, and that specifically needs to discuss the treatment with considering the risks and the benefits of the treatment, how that treatment will affect their, will it increase their earning, or not their earning, but their ability to return to work in some capacity. And if the doctor agrees with this treatment plan, or if the treatment plan's out there and you get an expert to discuss the specifics in that area of, yes, let's say use a detox program. A detox program is non-invasive. It would have great benefits to the injured employee without creating any risk there other than some minor withdrawal effects. The usual risks that everyone is posed to. And what this will do, if you wean them off the opioids and the medication, they'll be able to go back to work. They'll be able to do whether it be a sedentary job or their full duty job, because they're not under the effects of the opioids. It's not. And then what you can do then is offer a detox program. And you have that offer out there. If the employee or the claimant refuses, you can file what's known as the refusal of medical treatment, or reasonable medical treatment. And if you prevail on that, you can suspend medical benefits. You can stop that.
Can the same apply for invasive treatment, like recommended surgery that the employee refuses to have?
It absolutely can. Those are a little bit tougher and a little tougher and trickier, but they apply to this. There's one of the most well-known cases, which is why it's called a Muse petition, is the Muse case, which dealt with a hernia surgery. And you can, again, if there's surgery recommended, let's say a fusion, the claimant doesn't want to proceed with it, you go ask a doctor to independently review that recommendation and examine the claimant. Ask the doctor to discuss the specifics. What are the risks and benefits associated with it? Do they outweigh? Will it create a greater earning capacity? And if it does, file that petition and say you'll pay for that surgery. And if you prevail, you get a suspension of medical benefits. Now,
for how long?
Now that's where it gets tricky. Is you only get the suspension until the claimant engages with the treatment.
So the claimant has a surgery.
Yes, in that case, till they have the surgery. In this case, which it's tricky, but what that could lead to is if they truly get it, they can get better. You get more. If you get job restrictions now because they had that surgery, go ahead and offer a job if you're able to. It opens up the claim to more options and more ways to manage the exposure, as opposed to watching someone refuse a surgery and stay in and basically be static. If you get the surgery, now you have options, job restrictions, VOCs, everything that kind of opens up to managing it at various ways.
And that was the point of the petition anyways, to have the person get the treatment that was recommended with a greater chance that it has a good effect.
Yeah.
So did you want to talk about out-of-state treatment?
Yeah, that's on there. A lot is unknown with that. So one thing to keep in mind, and it is a tool to keep in mind with respect to your medical exposure, is with out-of-state treatment, you still are only required to pay up to the fee caps. Now, that depends based upon whether or not the provider is licensed in the Commonwealth of Pennsylvania and they maintain an office in the Commonwealth of Pennsylvania. In those cases where that's the case, but the doctor's treating them out of state, you only have to pay up to the fee caps that's associated with where the doctor's principal place of business is. If the claimant's treating out of state, but the doctor is licensed in PA, but does not have a business or a practice in PA, physically in PA, you are to use, it's reimbursable with the fee caps that are located in Harrisburg, and that's paid in accordance with the medical cost containment regulations for that area for Harrisburg, Pennsylvania. The same goes for if the claimant is treating out of state with a doctor that is not licensed in the Commonwealth of Pennsylvania as well.
So the bottom line is, even though you're getting bills from an out-of-state provider, fee schedule is going to apply in one form or another. Yeah. It's just based on what jurisdiction controls the fee.
Yeah, don't pay more than you need to. That's the end game here. And sometimes that happens, and you need to look at it, because down the line, These things add up, especially as medical grows more complicated.
All right, we're just going to wrap it up with a couple of practical tips, which is really just general approach to things as opposed to these, to be applied in employing these specific tools. You just want to be flexible and sensible. Don't dig your heels in unless you have a really good reason. Be able to react to new information, do what makes sense, and you'll be better off in the long run.
I think the biggest thing is, and it starts with that panel, which is a great tool, is, again, medical is so complex, but at the beginning of the claim, you can set the tone. You can really set the tone for medical. And the purpose of medical, at the end of the day, is to get the employee back to work. It's to get them better. So again, as Steve said, be flexible, be sensible, manage that relationship. The medical should work for both of you, both the claimant and you. That is why you have it. So manage your relationship. If the claimant does want to get one injection and that may help, don't be scared if you just pay for it. The point, if you deny it, then you risk them going to get an attorney, then the treatment starts to spiral. Manage the relationship. Pick your battles here.
Pick your battles and know where you're going. If you think you're going to wind up in litigation because you know the players, the doctors involved, the attorneys involved, marshal your resources, gather your evidence, do the IMEs, do the record reviews, do what's necessary to give yourself a good outcome. You don't have to do that in all cases, but know when you're going to up the ante and have a bigger battle on your hands. That's when you want to pull out the stops and do what you really should.
And again, keep in mind that just because you're paying for one medical treatment, you're not admitting liability here. That's something to keep in mind. You can pay the medical on certain treatments without admitting liability.
And sometimes if it's just a minor thing and you think it's going to get the claimant back to work, you're better off doing that than drawing a line and establishing a tone where a claimant now feels everything's adversarial and turns to an attorney, and all of a sudden things break down. And 5 years later, you're asking us for those advanced tools to get out of the case. If sometimes it just is a matter of keeping the claimant in the fold, in the system that he feels he's being taken care of. And if you do that, even if you compromise on a bill or two, you might have a better effect in the long run.
I think one of the, an example here would be, let's say you have someone that has a low back injury, but now they're saying my neck's been hurting, and a doctor says, well, we want to get an MRI of the neck. And let's say the injury is totally low back. If you don't have to pay for it, but let's say you're starting to get some tension there, get the MRI. And just because it may not, if it shows nothing there, you don't have to do anything. And even if it shows something, you paid for something that's a few $100, but you don't have to pick it up. You don't have to accept it, but it keeps that relationship there. The claimant's unhappy, and then you can start to line your tools up and really get that plan of action moving. It's these little battles that could really start to kick everything out of control, and you got to manage those and pick them.
We'll just end with this. Good treatment is the goal for good results, and most of the tools we talked about is to avoid the bad treatment and the problems that can arise. So treat claimants right, and you get a better outcome.
Absolutely. So thank you for attending our webinar today, Stopping the Bleeding, Ways to Manage Medical Claims in Pennsylvania. You can learn more about this program and all other Weber Gallagher events by visiting our website at wglaw.com. Thank you all.